Thank you. Be seated. Good afternoon. Now is the time set for oral argument in cause number 1 CV16 0398, Palmer versus the City of Phoenix and Grand Canyon University. For your information, and I know this won't come as a shock to any of you, these proceedings are being both audio and video recorded, so absent any technical issues that we have no control over, both audio and video should be available for you to critique on YouTube in a few days or a few weeks. Counsel, each side will be entitled to the usual 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know and we will try not to take it all from you. However, ultimately, it is up to you to reserve that and maintain that time. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument. And we tell people that so we can tell you, please fashion your argument accordingly based on where you think the best use of your time can be. You can make the best use of it. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And before we go any further, counsel, is it going to be one or two people arguing today?
Your Honor, I'm Adam Decker representing Grand Canyon University. Paul Lee is here on behalf of the City of Phoenix, and my approach would be to reserve time for Paul Lee at the end of our 20 minutes for any time that he would like to have. The rule
remains. If you want to split your time, it's up to you to be the one who assiduously protects that, okay? Thank you. So with that, as I said, when each of you come to the podium, I'd ask that you state your name and who you represent. And with that, appellant's counsel can begin.
Thank you, Your Honor. I am Timothy Lasota. I am here on behalf of the plaintiffs' appellants, Gail and Janice Palmer and Gary Perkins Warner. And may it please the court, I would like to reserve 4 minutes for rebuttal. And I think just at the outset I should note that there are essentially three independent reasons why my clients should prevail in this matter, and the ruling of the trial court should be reversed. The first is that the street that was abandoned in favor of Grand Canyon, or it's abandoned and going to be sold, it's kind of been a shifting target for us, but the street is clearly still necessary for public use because the city is requiring whoever buys it to maintain the street for public use. The second, I'll get into all these in a little bit more.
Counsel?
Yes.
I got to jump in here. Is that a question of available for public use generally? Is there a limiter on how you define public use? Is it just for the families or just for the folks who will continue to own property outside of the university on that street? How do you define that?
Well, good question, Your Honor. And I think we have to go back to the statute, which says that in order to avail themselves of this process, the city must essentially determine that it's, quote, not necessary for public use as a roadway. So I think that's fairly broad. And I think that this is still necessary for public use as a roadway because if we look at the stipulations, they say that when GCU buys this, they will not restrict movement of pedestrians using the roadway to access Little Canyon Trail. People use roadways for different things. They use roadways to drive on. They use roadways to walk on. People might cycle on this roadway. But this roadway leads right to a linear city park. So it's a little bit awkward for the city to say, on the one hand, this roadway is not necessary for public use, but we're going to demand that whoever buys the property, which we know will be Grand Canyon, has to maintain it for public use. Clearly, that does not meet the statutory definition, which is, I think, where this court should start and end.
Let's, if you could, please, let's stop there. The city's decision to abandon is a legislative decision. Isn't that right?
That's correct, Your Honor.
It's a legislative decision. Under Arizona Supreme Court case law, the Reese cases, in order for your clients to challenge that legislative decision, absent illegality, which we can come back to, they had to show some evidence of special damages. And I don't see anything in the record from either at the hearing, in the record, at the hearing before the the hearing officer, and then in the city council, and then in the trial court, and there certainly was no offer of proof that you made, of any special damages. So I don't see how, on that particular issue, you're able to take up and challenge the city's exercise of a legislative decision.
Well, Your Honor, with all due respect, I think that misreads doesn't state the Reese case the way the holding is, and I think Reese stands for well, you said, absent absolute illegality. This is absolutely an illegal sale of a public road under 7202.
Let's put that aside. This issue, as you briefed it in this court, and as you presented it to the trial judge, was an attack on the city's legislative determination that public use was no longer required for this roadway, or putting in the positive, that the roadway was no longer needed for the public's use. To attack it on that the decision is arbitrary or improper, that is a wrongful exercise of that decision-making, you still have to have special damages, and I don't see any special damages.
Your Honor, I think that argument was actually waived by the appellees. They only brought.
Let's assume for the moment we don't agree it was waived. Okay, they raised it second day. You had an opportunity to respond to it. You could have filed some type of paper later that same day. So I don't think it was waived. If it's not waived, then let's go back to my original question. You haven't presented at all, at any step, any evidence of special damages. So therefore, is that argument properly before us?
Yes, Your Honor, that argument is properly before you. It's unclear to me where we would have raised the issue of special damages because the trial court ruled that you had to review the record from the.
Well, you brought a special action.
Yes.
Okay. Instead of a different type of proceeding. So once you brought a special action to attack a decision as being arbitrary and capricious, you were limited to the administrative record. Therefore, the time to bring it up, arguably, the it in that sentence being special damages, was either in the proceedings before the hearing officer, the proceedings for the city council. So you had an opportunity to bring it up. At a minimum, there needed to at least be an offer of proof in the Superior Court, so at least we'd have some record of what special damages are. So there was, but there's an opportunity. So without any proof, any step of the way of special damages, how do you get to challenge the city's exercise of its legislative decision-making?
Your Honor, it's because the city can only make this legislative determination if they meet the conditions of the statute that it's not necessary for public use. And they cannot say that it's not necessary for public use if it is necessary for public use.
That's the whole point. Isn't that the whole point? It's like the dog chasing its tail. The city made at least an implicit determination this is not needed for the public use. You challenge that, and you want to say it's wrong, it really is still needed for the public use. And the Reese cases say categorically you don't get to do that unless you have special damages.
Well, Your Honor, or unless it's absolutely illegal. And this, in this instance, we didn't quibble with the testimony from witnesses who came and said that we want this or we want that. We didn't quibble with the city's decision as a legislative entity that this road should be abandoned. We pointed out that they are not free to make that decision because they've admitted that the roadway is still necessary for public use. We only get into Reese if they actually have the legal authority to abandon this property, which they never had in the first instance.
Forgive me, because this is an important point. We're mixing apples and oranges. I do understand that you have argued that under the terms of the dedication and under other provisions of state law, the city cannot abandon this because it was dedicated as a roadway for the public use. So that's the illegality argument, and I understand that. But separate and apart from that argument, insofar as your clients are attempting to challenge the city's exercise of legislative discretion, which is we don't think it's needed for the public use. and I know you want to rely on and have relied on the stipulations. Nevertheless, that is a challenge to the city's decision-making. And that's off limits unless you prove special damages, isn't it?
Your Honor, this isn't really a challenge to the city's legislative decision-making, and I agree with you. In the normal course of business, if this weren't a case that they normally wouldn't take up for abandonment, in the normal course of the city's business, if they decided they wanted to abandon a street and that the street was going to, I can give you, the street across the street from us was abandoned because the school purchased the land on both sides. So the city's decision in that instance is clearly subject to legislative deference because they clearly had the right to abandon that road. That road no longer exists. It's now part of their baseball field. Clearly, they have the right there, and if I wanted to go challenge that, I would have to overcome the Reese standard. But because we don't have a situation in which the roadway is not necessary for public use, they never get to that Reese situation because they never have the right to abandon the road to begin with. If they had the right to abandon, if they had the power, I should say, the power to abandon this road, then what they did would be subject to legislative deference, but they don't have that power to begin with.
But again, illegality is one issue. The exercise of legislative discretion, and I don't want to beat and use up all your time. I don't hear any response to my questions about lack of special damages. So it seems to me that you then are limited to asserting that the proposed abandonment here was illegal, which is the argument you raised in your briefing as well. And let me share my concern about that. The 1913 code that was in effect when the property was dedicated had a provision that both authorized people to dedicate property, and it instructed that when the city or the municipality received the property, it would be held in trust for the public's use. And that language is somewhat similar or tracks the language in the dedication. At the same time, in the 1913 code, there was a provision that authorized municipalities to vacate, which was the word that was used then, that means to abandon. So the 1913 code both authorized simultaneously the city to receive by dedication and the city to vacate or abandon. So given that, how can you say that the city can only receive and never give back or never vacate?
Your Honor, the city can vacate, and they could always vacate, but when the critical 1913 statute, the specific provision states this, it's, quote, the fee of all streets, this is the dedication statute, and it says that once the dedication is made, quote, the fee of all streets reserved therein to use of the public shall vest in such town, if incorporated, in trust for the uses therein named and expressed, end quote. So basically we know what the words in trust mean. They mean, when someone gives me money and I hold it in my trust account, I can't go and just spend that money. That means that they're not just holding this property outright, that they hold that in trust for the person, for the public generally. So you have to so even though they can vacate roadways, they have an absolute right to vacate a roadway if they own it outright. They have limited rights to vacate roadway if they hold it in trust.
And what Arizona authority supports that argument?
Well, the Cochise v. Sierra Vista supports
right, and
that.
In that case, I don't remember what's the state Supreme Court or the Court of Appeals, but in any event, the appellate court held that in general, when you have a dedication, the terms of the dedication control. It did not address the situation, which is when a city determines that dedicated property is no longer needed for the public use, can it abandon it? And the trial judge asked you this question multiple times, which basically was, aren't you really arguing that once the city receives property dedicated to it in trust, then it has to maintain that property in perpetuity? And you never gave her an answer.
Your Honor, I think I did give her the answer that I'll give you now, and that is that they don't have to maintain it in perpetuity. They can vacate it back to the original owners.
Which are not your clients, nor are they your clients, the original owner's descendants.
But they are their successors in interest, and these rights should run with the land. I think I cited...
Did you find those interests, counsel? Did you go out to find the people that you say holds fee on this property?
Those people are dead, Your Honor.
Oh, doesn't that answer your question? We're going to return it to dead people?
No, the interest of the interests run with the land. In other words,
So the land holds title to the land?
no, but the right to receive the returned land runs with the land. So in other words, because it was the original landowner who vacated this property in favor of the city, the successor landowner is the one who should benefit by return of the land. I mean, if we think about this situation, well, Your Honor, the original owners dedicated this land for public use as a roadway. And that was in the dedication document, and the statute says that the city's ownership of the property is in trust. It is not free and clear. So that land was part of the original plat. It was part of the property. It was dedicated only to be used as a roadway. If it's no longer used as a roadway, it should go back to the successor landowners.
Pat,
Well,
28's the provision that the city is proceeding under, 287205, I believe, that allows for a sale, has a very defined definition of a budding owner. Your clients do not fall within that definition. Therefore, since the city is free to choose a sale versus just simply abandoning it to under another section to the abutting owners, your clients don't have rights under that section.
Your Honor, we don't have rights as abutting owners under 7205. I agree with you with that, but we do have rights as abutting owners as the successors to the original dedicators, because the statute in effect at the time says that property is held in trust. And since the property that property was dedicated for the benefit of the future landowners so that they could have a street. It was not dedicated so that the city could go and sell it to Grand Canyon because Grand Canyon wants it.
I just don't see any legal authority supporting that argument that you have given to us that we can use to agree with you.
Your Honor, there's the 1913 code, and there's also, which says that it's held in trust.
The words in trust do not govern the mechanisms of the abandonment. And you are attempting to engraft into that provision requirements that the statutes do not impose on a municipality when it decides to abandon property by sale. I just don't see it.
Well, Your Honor, I cited I don't think there's an Arizona case on this particular point one way or another, but I cited a number of out-of-state cases for the proposition that when city accepts a dedication, a statutory dedication, the dedication document essentially becomes a contract between the city and the landowners or the successor landowners. I cited the 2000 Baum Family Trust case from Michigan. I cited an Alabama case. Antho on municipal corporations stands for the proposition that when city takes title to a property in trust, its use of that property is limited to the dedication document.
Counsel, what's your best case for the argument that when a person buys a house, they get fee title to the streets? Each one of them gets fee title to the streets. You go into a new subdivision, right?
Yes.
You buy the house. And you're saying that when they buy the property, and I really want to be sure what you're saying here, you're not saying the people that owned the property that the original grantor now owned back then get title to those streets. You're saying that when a person buys a house in a subdivision, new subdivision, they get title to their property. It also inherently allows them fee title to the streets themselves.
It doesn't allow them fee title to the streets, but if it was dedicated in this fashion, it entitles them to return of the property if that property is ever vacated. And the reason is because that property is held in trust. It's not held outright. The other thing I would point out is that, the trial court did agree that the city cannot pre-commit to a sale to a particular interested party. And that's because 7204's provisions contemplate a notice, public notice at a sale. I think that clearly means that this property has to be held out in a legitimate public sale. They have done everything possible to make sure there could be only one interested buyer. This is not an auction. This property has already been effectively sold to Grand Canyon because whoever buys it, and frankly, a person other than Grand Canyon would have to be a fool to buy this property because the stipulations ensure that it is turned into the entryway to Grand Canyon's campus that it wants. I'll give you I think what is the worst example. A third party who bought this property would not be able to drive their car on the property, but Grand Canyon would be able to use the property to drive their golf carts on the property.
So you're saying that the people owning property on that street will not be able to legally get to their houses?
That's not correct. I think of a third party, someone who's not a party before the court now. Me, if I wanted to buy that property, I would not be able to drive on that property, but I would be required to allow Grand Canyon to drive on the property. And that it's true because the stipulations are that only the current property owners get access to it, current property owners in Grand Canyon. So this fictional third-party buyer that they're talking about that could come along and purchase the property, this would be like offering a house for sale and saying, yeah, you can buy this house for sale, but you gotta let them live in it in perpetuity.
Here's my concern about that argument, and I'll be clear about this. I think you have raised a very good point, that this clearly is a sale in which the stipulations are such that if I was a betting person, I would say there's going to be one bidder, and we know who the bidder is going to be. It's going to be Grand Canyon, and the bidder is going to be successful. Putting that aside, and I understand the argument, the concern I have is this. The statute on its face, 287205, is process-oriented. You have to you provide notice within so many days, you post, so it deals with the process of the sale. It does not deal with certain exceptions of the content of the terms of the sale. And what you're describing are the terms of the sale. And I agree, the terms, if this was a procurement code issue, there would be a serious procurement code problem with these terms. But that statute deals with process and not the terms. And normally we have lots of case law that says we as judges, we as courts cannot read into statutes restrictions and requirements that the legislature didn't put in there in the first place. And it seems to me that's what you're trying to do.
I'm out of time. May I answer
go ahead.
the question?
Yeah, plenty of time for that question.
Okay, thank you. Your Honor, I'm not asking you to read in restrictions. I'm asking you to read the statute in a fashion in which the statute actually makes sense. Because unless we contemplate an actual public sale here, there is absolutely no reason to put these public notice provisions in. If the legislature had intended that the city or town had the power to convey this to a private party outside of this public notice process, like they've done with Grand Canyon, there would be absolutely no reason for the state legislature to require that these public notices telling people that the property is going to be sold go up. I mean, I think that's that's absolutely how to read the statute. It's not reading anything in it. I think it's going back to the courts have to interpret statutes in a way that they make sense. And if we say that the city can which exactly as you've described, if we read the statute that way to allow the city the power to do what they've done here, this statute no longer makes one iota of sense, because there's no reason to tell people to post notices and to tell people they can bid on this property when the reality is they can't unless they're just there's no reason to have this unless a public, actual, legitimate sale to whoever wants to buy it were contemplated.
Counsel, doesn't that ask us to presuppose that each sale must appeal to a certain body of people or a certain number of people or a certain group of people? I mean, is that our job?
Your Honor, I think that that the sale has to be a legitimate, open, public auction. I mean, I think in any sale you're going to have certain subgroups of people who are more interested than others. But I don't think, I mean, I'd go back to what the trial court said. I don't think they have complete discretion to completely exclude every other person from this process other than Grand Canyon, which they've done through their stipulations.
Theoretically, someone could come in and say, you know, I've got some money here. This is an investment. I'm going to bid. And I know I've got some of these impediments and so forth, but that's going to really tie up Grand Canyon. And you know what? They're going to come to the table, and they're going to deal with me, and they're going to give me my price because they want this property. They want this abandonment.
Your Honor, I think with the stipulations that Grand Canyon has and the city have put into it, that person, even if there were such a person out there, it wouldn't matter because the person still has to maintain the property as a private entryway for Grand Canyon. So Grand Canyon would probably laugh if someone came and bid on the property other than themselves because the stipulations are such, that person can sit there from here to eternity and say, come to me, Grand Canyon, come and pay me the money for my property. And Grand Canyon just sits there and laughs and says, why would I pay you 1 cent for this property? I already own this property because the property is being used exactly as I want it used. It's being maintained for Grand Canyon pedestrian traffic. It's being, we have the guard booths that Grand Canyon wants. I mean, we've got an indemnification provision in there just in case they run into legal, which in case there's any legal trouble. I mean, this property belongs to Grand Canyon in every sense of the classic view of ownership, in that they get to do what they want with the property. So they will never have to wait for, if someone else buys it, Grand Canyon will never come calling because the property is already being used as they want.
Thank you, Councilman.
Thank you.
Good afternoon. I'm Adam Decker, and I represent Grand Canyon University. May it please the court, Grand Canyon has a clear the City of Phoenix has a clear statutory right to abandon whatever property and roadways that it owns in fee title. There is no explicit requirement in the statute that the city makes an explicit finding in any hearing or at any time that the roadway is no longer necessary for public use. So long as the city determines that on its own exercise of discretion, that a roadway is no longer necessary, then it can abandon that road. And a roadway as defined in the statute would also include, or specifically includes, parts of a platted or designated public street. And that's what we're dealing with here. We have a platted street from the 1926 dedication. There's only one restriction on any abandonment that a city or governmental entity has defined in the statutes has when abandoning a roadway, and that restriction is to make sure that any landlocked property owner has ingress and egress and the ability to have public invitees, guests, and public emergency vehicles and similar vehicles access to that adjoining property owner.
So is what we're talking about here is basically one road in, one road out, same road out?
What we have is we've got two roads in both Coulter and 30th Street, and both roads will lead to Grand Canyon, to a cul-de-sac, which is abutted by the appellant's properties, Your Honor.
I'm not sure I understood your point. 287202 specifically says if a governing body determines that a public roadway owned by the city, etc., or a portion of the roadway is not necessary for public use, it may dispose of or use the roadway as provided in this article. So the predicate for any action of disposition of the property is that there needs to be a determination the city has to determine is not necessary for public use, right?
Correct.
So the city has to make a decision that the property or the roadway is not necessary for public use.
That's correct.
Okay.
That's correct. There's nothing in the record that says that the city explicitly made that
No, and I
determination.
understand that. I think, however, to say the city didn't implicitly make the decision, kind of, why are we here?
You're
Yeah.
correct. I apologize. I misspoke.
Okay, I got you.
When you look at the 1926 plat map, there's, and we've addressed this in the brief, and I guess I also want to focus on, and I may jump there if we need to right away, but in the plat map there's two ways to dedicate roads to the public use. One is the common law dedication, the other is statutory dedication. With the common law dedication, that is where, for example, an easement is created for the public at large. That easement, the ownership, fee title, stays with the dedicating party, and the use goes along to the public or to the city or county, wherever the property happens to be located. With the statutory dedication, you look at the plat, and this has been the law since the 1913 code, which is if you have a dedication of a plat map with lots and roads and various legal descriptions, including, let's see, not just the lot, the width of the roads, the lots. If that gets recorded, then what it's considered is a statutory dedication, and then fee title conveys to the county or the city. In this case, at least at this point, that fee title was held with the city.
Counsel, my real estate law training, law school, said that basically there are terms of art that we use in the conveyance of land, right? And we've talked about fee title, who holds fee title. Is there any indication here that there was any lesser estate of property than fee transferred, or that fee was retained by anyone?
No, I don't believe there is any lesser estate, and I'll direct the court to the Maurer versus City of Tempe case. In that case, there was a determination that the recording of a plat resulted in the fee dedication of the property of the roads to the city. And in that case, and I want to focus on what it means in trust. Who is the property, who is the road being held in trust for? The appellants suggest that the road is being held in trust for the original property owner. We say that this is a mistake. It says specifically in the Maurer case that by which the fee and the dedicated property passes to the county in trust for the public for the uses therein described. The trust is for the public, which means it's a public dedication resulting in a dedication to the city or the county in that case. So the fee title is transferring in trust if that trust was ever released. And I think that's the interesting operation of how all these statutes work. You have the ability to, a dedicator, a subdivider, can create a subdivision, can put the roads and the streets, can have that recorded with the requisite language that says the roads are going to be held in trust for the public. And under the Arizona law, that's a statutory dedication, meaning that the city is now taking title to those streets.
And if anyone is to ever convey fee, who is that?
It would be the city at that point, because the city now has fee title ownership.
Is there any authority you're aware of in Arizona indicating otherwise?
Not that I'm aware of, Your Honor.
Are you aware of a case that ever transferred city streets back to an original grantor? That was not, well, go ahead.
Well, to answer that, no.
If you give someone gives a tract of land to the city, has it developed? And I think the way I understood the argument, appellant's argument, was that the grantor holds fee. Is that right? That's the argument?
That's his argument, correct.
Do we have any case law that says that at the time of abandonment or at the time that the city no longer needed the road, it went back to the developer?
Not case law, no. I think that's where you get the statute. I guess I've tried to put all this together to try to figure out how this works since for the months that I've been involved, and several months I've been involved in this case.
So tell us, how does it work?
All right, here's how it works. The city has the ability to take a road that has fee title, and it can abandon that. It can hold on to that. I think the way that the law is set up is that the city can sit there and hold on to that property until it finds no other reason to hold on to it. It finds it useless for the public. It's unnecessary. What's interesting in the statutes is there's nothing in the statute that says the city can just voluntarily go out and impose an abandonment upon a neighbor. I think 7215 says, in B, says that if the city wants to, it can even waive the compensation requirement so long as whoever it's giving the property to agrees to maintain it. But on the big picture, the city has the ability to take the property, that's given to it by, and really, and there's the Richardson case that's not even referenced. But I mean, it's a Richardson case that I lost before this court, and so there's things I remember. But in there it says that the city that the state or the county doesn't even have to accept title. I think the law is if there's a public dedication, automatically that goes to the city or the county. Let's say the city in this case. So even without knowing it, once the plat is recorded, the city's taken title to it. Months can go by, years can go by, and at some point, somebody can petition and apply to the city for the abandonment. And once that happens, and this is Mr. Lee's argument before the Superior Court, there's a nature in that application who's doing the application, who wants the abandonment, that the abandonment should be favorable to the applicant. Otherwise, why would you apply for an abandonment unless you're trying to have some benefit from it? But
Is it necessary to demonstrate the benefit they will receive?
There's nothing in the statute that says that there's anything to demonstrate it.
Kind of like a good investment versus bad investment?
I believe so. If
Someone wants to take a risk, that's their business.
I can go and ask for the abandonment of the road in front of my house right now with the city of Mesa, and whether the city will accept it or not, it's greatly unlikely because of how it's used. But back to here, why I think it's interesting when you talk about the abutting property owners, and you ask, is there a case where the grantor, city, gives back the property to the abutting property owners? I don't think there's a case there, but the law presupposes that may be a condition that happens. That may be a circumstance that would occur. The idea being that the city is going to go ahead and is going to receive something from the grantor. He's going to get something and then decide at some point that's going to abandon that. What the legislature decided is, hey, if there's going to be somebody who's being benevolent and is giving something to the city, if the city turns around 5 years later and says, I'm going to abandon this, and I'm going to exercise my option either to do a public sale or to give it back to the adjacent property owners, at least as far as the public sale goes, what the legislature said is, we don't want the city to then say, hey, thanks for taking care of me. Thanks for giving me this road, but now I'm going to do a public sale. I'm going to make a bunch of money on something that you gave me just 5 years ago, just 10 years ago, just a lifetime ago. At least if you're a direct descendant, we're going to take care, the legislature is saying, we're going to take care of the direct descendants. We're going to take care of the original grantor and make sure that they get it back for the price that the city paid. And if that's a gift, then they get it back as a gift. That's my reading of the statute.
What about the argument then that I was discussing with Mr. Lasota, that this really isn't a public sale? And we really know it's not a public sale because no one in their right mind is going to bid at that sale.
Your Honor, the argument you mentioned to Mr. Lasota is the same argument I mentioned in the trial court.
I know.
I'm
not that smart. I read the record, so
you may have an investor who says, I'm going to take advantage of this, and we're speculating here. But I'm guessing that if there's a bid process, if somebody who received notice and saw there's a public sale and knew that this is going right down the hub of the Grand Canyon heartland and wanted to make a bid, even if that potential bidder, owner, knew that there was going to be even a restriction of his use, he still has all the bundles of sticks, right? He is the primary bundles of sticks. There are a few he has to give away, but he's holding that. And what's interesting is if you even look at the stipulations for the city, for example, the road narrowing, there's a prohibition against narrowing the road so long as the current property owners own the property. The idea being that at some point, those property owners may sell. Will they sell to Grand Canyon? Potentially. Will they sell to somebody else? They may. But what's happened here is Grand Canyon has expanded. They've expanded. They've grown. They now, as far as a surface...
Let's come back to that question, though, because you haven't convinced me. So...
Oh, I know where it's going. Okay, go ahead.
So what buyer is going to buy or bid on or attempt to get this property other than your client?
We won't know until we do a notice.
That's not a very honest answer in my
No, well, all I can perceive of
there's going to be one, right?
There's one for sure. That'll be Grand Canyon.
You would be shocked if somebody else did it.
Well, I wouldn't be shocked if Mr. Palmer or Mr. Warner made a bid. And I guess I would be shocked if the only other property
all
owner
the
out there.
stipulations in place.
Well, as Mr. Lee mentioned in his argument in the lower court, those stipulations would be, except for the manned gate, which is something that Grand Canyon proffered, the stipulations would be the same whether it was for Palmer and Warner, if they were making the application for the abandonment, or whether it was for Grand Canyon. You need to remember that this was a result of 2 public meetings with significant evidence, witnesses, and other people making offerings about what was going to need to be taken care of and what interests were going to be taken care of. And those stipulations are also there to benefit Palmer and Warner. They're not just to the benefit of Grand Canyon. There are benefits there also to the city.
But that's not the issue. The issue is, with all of the stipulations, who could possibly bid on this property other than your client? And what benefit could they possibly obtain by making such an offer or bid other than your client? Your client is going to be the one who bids on this property, and no, to the exclusion of everybody else.
If you wanted a sincere answer,
Yeah.
here's
Well,
my
yeah.
sincere answer.
You negotiated with the city. You negotiated exactly what you wanted to get the sale for your client. And I'm not saying you personally.
I know, and I'm not taking it personally. But the process resulted in these stipulations. Does it feel good? Does it feel like an open bid? Does it feel like a public auction? Not necessarily. Is it contrary to what the statutes require? Not at all. There's nothing that is proposed in the stipulations. There's nothing proposed in the application. There's nothing proposed in the final memorandum from the city or the unanimous decision of the city council that is contrary to the statutes. There's nothing illegal about it. Restrictions in property in Arizona are alive and well. We have restrictions with HOAs. We have restrictions as to use, to ownership. Last time I checked, the rule against perpetuities is still alive and well to some degree in the state of Arizona. There are subdivisions, accesses, abandonments, even the, or not abandonments, even the, what comes to mind is the Phoenix Arizona Cardinals stadium, which was land that was given to the Cardinals, but the Cardinals said, the state stepped in and said, I think it's the sports and the Sports Authority and Tourism Authority came in and said, well, we're going to give it to us, and now we're going to be the landlords to the Cardinals. I've not looked at that lease agreement, and I've not looked at the restrictions provided by the owner, but I'm sure it's full of restrictions. So I don't...
If that's all true, and I'm not saying it isn't, then what's the purpose of having public notices if you don't anticipate you're going to be able to get more than one bid?
Because there may be the off chance, and I know I'm trying to be sincere, there is the off chance that once the notice goes out that somebody says, on a long-term investment, I want to buy this road and I'm going to challenge Grand Canyon University for it. Whoever that person is, I don't know. Will we know whether they show up? Is unlikely, if my sincere response, but there could be. There could be somebody who says, look at the expansion. The record's clear. $400 million of growth from Grand Canyon University. The part of the result of the unanimous decision came from the police commander of that area, who said that the safety has been great, that the security and safety will be greatly benefited if this abandonment occurs and Grand Canyon is able to then impose these stipulations to the benefit of all the surrounding property owners. The odd thing here is that Grand Canyon has grown, and it's grown exponentially. And we have two property owners who are observing it. They're firsthand witnesses. And where decades ago, maybe they had the mailman and a couple other people would come across their walkway, and there wasn't a lot of foot traffic. But what's happened is now there's significant foot traffic. There's 5,000 employees that come into Grand Canyon. There's 16,000 with the anticipated 25,000 students who come into Grand Canyon. As Mr. Lasota said, there's a ball field. Everything around the Appellants is growing. And I understand the appellants want to protect their property, and they have every right to do that. It's their property. They have all the rights and benefits of being fee title holders. But at the end of the day, an application was made for an abandonment. It was made by Grand Canyon. The city had 2 hearings, took evidence, listened to witnesses, listened to the appellants, and tried to make sure that stipulations were in place to protect their interests and their property interests.
And then noticed a sale that only your client can really bid on.
We'll notice a sale that is open for anybody, but the result is, in all likelihood, it will only be Grand Canyon University who will make the bid. Do you have any questions
Counsel,
for Mr. Lee?
I know, can you give me, let's put 3 minutes on each of the clocks because we're going to let Mr. Lasota come back up. I did what I said we were going to try not to do, and I took all your time.
No, I think I took it.
And give Mr. Lee, give Mr. Lasota and Mr. Lee 3 each, please. Mr. Lee? And counsel, thank you. I didn't mean to be dismissive at all.
Oh, you're the one. Thanks.
Thank you, Your Honor. May it please the Court. My name is Paul Lee. I'm Assistant City Attorney for City of Phoenix. I'm going to keep my very brief. I probably won't take up 3 minutes. I just want to address the question asked by Judge McMurdy at the end about who could potentially bid for this property. As I'm sitting here listening to this dialogue, I just realized GCU certainly is a favor and most likely party to bid on this particular auction, if there is to be an auction. But I can imagine other parties who want to take advantage. For example, the appellant who owns the property may eventually want to rezone his property, turn into, let's say, a student housing. Having some control over the streets in front of his apartment has a great value to that person. You can put signs, flyers that wouldn't be otherwise permitted in a public street. Or another developer who comes in who wants to buy the property in the area that's going to be abandoned, sure, they have to allow GCU access, but they also can take advantage of the fact that GCU will provide a guard at the gate to provide additional security. So there's potentially some other people can come in and bid on it. So I don't think it's disingenuous to assume that there may be other parties who may be interested, despite the fact that these stipulations are for the benefit of GCU. The other thing I want the court to keep in mind is that these stipulations are also for the benefit of the appellant. GCU, if they were to buy this property, cannot shut the appellant out. They still have to provide access to the appellant, unobstructed access. That's how the stipulation puts it.
So, Mr. Lee, I do have a couple of questions.
Sure.
First of all, have the performance of the stipulations, have they been completed?
Your Honor, as far as I know, they have not been fully completed. My understanding is that the GCU came in, asked for an extension of the 18-month period to complete all the stipulations, but my understanding is that they're pretty close.
Actually, may I ask Mr. Deckert to address that? The stipulations, the period of performance was specified through and before, or on or before January 15 of this year. I take it then that GCU hasn't completed all of its work, but asked for an extension, as Mr. Lee was saying?
That is correct, Your Honor. My understanding is that Grand Canyon University has done quite a bit of the stipulations, but there's this case, and so we're waiting on a result there. And so an extension has been requested and was granted by the city.
Okay.
Mr. Lee, I've got a question for you.
Yes, Your Honor.
If a municipality had a piece of property that stood to provide tremendous liability to them, that they weren't able to properly attend to it, let's just say, and it stood to create a real serious liability, and it was only attractive as a purchase to one person, would that preclude them from putting it up for bid and selling it, or would they have to guarantee that there would be more than one legitimate buyer at the sale?
Your Honor, absolutely not. We don't have to guarantee there are more than one seller. In fact, the statute even provides that the city can directly convey a abandoned right-of-way to the home HOA directly without even going through public sale. And that makes sense because I live in a community that a while back talked about having to gate our community for safety reason. And if we were to form an HOA, if the HOA gather enough signature, the HOA can file a petition to request the city to abandon the road. If the city agrees to abandon the road, there will be a direct conveyance from the city to the HOA. In that case, there's no public bidding process. So if a statute allows a direct sale to a particular party for a road that no longer has a public benefit, there's no statutory requirement that requires the city to make the bid condition equal to all interested party, generally speaking.
Thank you, counsel.
Thank you, Your Honor. Unless you have any question, I have nothing further. Thank you.
This panel has no more questions. You know that you got.
Thank you, Your Honor.
Thank you. Mr. Lasoda.
Thank you, Your Honor. And I would first point out that as to your question, that if the City of Phoenix does have a property with a lot of liability, I think clearly they have no obligation to ensure that there will be multiple bidders. But I do think under the statute, they can't go out of their way to make sure there will be only one bidder. And I think that's a big distinction in the example you asked. And following up on that, there will be no bidders on the part of my clients, simply because, well, if they were to buy this property, presumably they'd have to have insurance on it. There are all kinds of people crossing the property due to the stipulations. It would be, I think, a significant mistake for them to buy a piece of property that they have almost no say over what to do with it. Now, if this were truly offered for sale, they might want to buy the property because they could extend their front yard like what happens in a normal abandonment. And the other thing is, of course, whoever buys it has to put up a cost bond to ensure that the requirements that GCU wanted in the stipulations, that those are honored. So that's another impediment to this fictional bidder that will never materialize, and certainly is not going to be coming from the ranks of my clients. And also the one other, just going back to the point of the Reese v. Dumond, the legislative, and I told you the example of the abandonment, and I think this will help clarify my point. The abandonment across the street from me, it was a City of Phoenix abandonment, and some neighbors grumbled about it, but the City of Phoenix says, well, you can get to and from your house from 3rd Avenue. So, yeah, we know right now you can use Stella Lane or 3rd Avenue, but going forward, you can use 3rd Avenue, and it's perfectly acceptable ingress, egress. That is a classic example of a legislative determination that is almost, it would be extremely difficult to attack because they've just made a determination that that the street is not necessary for public use as a roadway anymore because you can use this other street. This is not an example of that because they never get to that legislative determination because the statute does not allow it in this instance, because by their own admission, the street is necessary for public use, and that admission is made in the stipulations where they say whoever buys this public roadway has to maintain it for public use, pedestrian use. Mr. Lee admitted the same at oral argument, which I quoted in my brief. So I think that's the difference between a legislative decision that is entitled to deference, which is, in fact, that's one of the reasons we didn't challenge it. It's because if as a pure legislative decision, it's very difficult to challenge, but as an illegal act that one is not permitted by the statute, I think our argument is correct because this is per se illegal because they cannot demonstrate it is no longer necessary for public use, having admitted in their own stipulations that it is still necessary for public use. So with that, I'm going to finish 7 seconds early. Thank you for the extra time, and thanks for moving the time of this oral argument.
Thank you, counsel. I will tell you that in my experience, we've never extended this kind of time before. It's not that we're being gracious, but we certainly were interested. I want you to understand that. We appreciate the argument. That's what it's about, is to give us some answers to some questions that we're not sure we have. Thank you for the time you've spent with us. We are going to take the matter under advisement at this time, and we will rule in due course. We're adjourned.